Good morning, everybody, and welcome to today's event. My name is Anu Sood, and I'm the Director of Marketing at Caseware RCM. Now, today's presentation is part 2 of how to enhance your implementation of the beneficial ownership requirement of FinCEN's customer due diligence rule. For those who registered for part 1 but were not able to attend it, don't worry, we have emailed you links for the recording. And Laurie has structured the presentation so that you will be able to follow along. We have also put on our website some of the, actually all of the questions and answers to the questions we had during part 1. And we'll send a link to those at the end of this presentation. Now, before I introduce our valued speaker, I'd like to quickly introduce Caseware RCM and Alessa. So Caseware RCM is a division of Caseware International and is exclusively focused on building great software to fight financial crimes. Alessa is Caseware's recently rebranded product for AML compliance and fraud detection, and actually fraud detection and prevention. And it provides all the anti-money laundering capabilities that banks, MSBs, fintechs, casinos, and other regulated industries need, all within one platform. So the capabilities include real-time due diligence, including identity verification, transaction monitoring and screening, sanction screening using third-party lists like those offered by Refinitiv, automated regulatory reporting, advanced analytics like anomaly detection, machine learning, and AI, and finally, dashboards to track the performance of your programs, workflows to provide step-by-step guidance to ensure compliance, and case management so you can track every step of your investigation to create a full audit trail, which is what is needed for full compliance. So without further ado, I would like to introduce you to our speaker. So Laurie Kelly has a 35-year career spanning the fields of accounting, finance, risk management, and regulatory compliance. Most recently, from 2006 to 2018, she served as the Director of Compliance for CoBank ACB, a $130 billion farm credit system institution, where she developed and managed the bank's anti-money laundering, fraud, and economic sanctions compliance programs. She holds a Certified Anti-Money Laundering Specialist designation, as well as a CAMS audit specialization. She helped found the ACAMS Colorado chapter, serving as the Executive Board Chair from 2016 to 2018, and Programs Director from 2015 to 2016. Laurie has done an excellent job of putting together today's presentation, and I hope you enjoy it. Laurie, over to you.
Well, thank you, Anu, and welcome everyone to this second in our two-part series discussing the challenges and recommendations in implementing FinCEN's customer due diligence, or as we'll refer to it, CDD rule. In today's webinar, we're going to first run through a brief overview and refresher on the CDD rule, and then we'll move into a discussion on storing, managing, and maintaining beneficial ownership data. And next, we'll talk through ways that beneficial ownership data can help your institution enhance your transaction monitoring and customer risk assessment. And last, we'll cover how important good documentation is to successful regulatory compliance. And I'll share with you one particular documentation methodology that worked very well for me when I implemented it at my bank. So a little bit of background here. Now, the CDD final rule was published on May 11th of 2016 after several years of debate and comment and revision. It represented the most significant change to AML regulations in the United States since the USA Patriot Act in October of 2001. It's also been one of the lengthiest to implement, over 4 years in the making, and with a generous 2-year implementation period, which closed on May 11th of last year. Now, it all started back in March 2012 when FinCEN issued its advanced notice of proposed rulemaking. There was an enormous amount of commentary and concern from the financial services industry about this, in particular about the requirements for financial institutions to identify beneficial owners of their legal entity customers. The Treasury Department held 5 public hearings around the country from July to December of 2012, and the feedback from these discussions helped shape the Notice of Proposed Rulemaking, which was issued almost 2 years later in August of 2014. Now, the commentary received on this NPRM was even more extensive than the advance notice, and banks and financial institutions expressed really quite realistic concerns over the beneficial ownership requirements, listing them as burdensome and lacking in value, as corporate ownership information is, for the most part, completely unverifiable. So everybody waited around for the final rule, which finally took nearly 21 months for FinCEN to publish. Now, something I find quite fascinating about the CDD rule is that it effectively represents the federal government making an end run around the states, who don't and continue to refuse to collect critical beneficial ownership information during corporate formation. The numerous pieces of federal legislation have been brought forward over the years trying to put this type of requirement on the states, but these have all failed, and not surprisingly, because anonymous corporate formation is big business for many states, especially Delaware, Wyoming, and Nevada. And one other interesting aspect of the CDD rule is that its release was well timed to coincide with the Financial Actions Task Force, or you may know this as FATF, their 2016 mutual evaluation of the United States AML regulations. Now, the U.S. received its lowest rating for its lack of effort to prevent criminals from using legal entities, mainly shell companies, to hide and move money or carry out criminal activity. And this has been a continual weakness in U.S. AML regulations, and really one of the primary reasons why the U.S. is still considered one of the top money laundering havens in the world. So our first topic today is about storing, managing, and maintaining beneficial ownership data. The CDD rule has the effect of creating an entirely new class of data for most financial institutions. We're now required to track the names and personal identity information of individuals who are related to a legal entity customer, but who may not have any direct relationship to the institution itself. Most likely, these people are not going to be account holders, borrowers, or even key customer contacts. And even if they are key contacts, most institutions have never stored anything other than names and contact details like phone numbers or email addresses for their key customer contacts. However, the people that are named under the control prong of beneficial owner could very well be key contacts. At my bank, for example, we stored names and contact details for the CEO, the CFO, and the board chair for every commercial client, but certainly not their social security number or their home address. It's also unlikely that financial institutions' legacy systems even have the data fields available to store beneficial owner information. But as we see in a moment, the method you'll use to gather beneficial ownership data has a significant impact on how effectively and efficiently you can store and manage this data. There are 4 key data management concepts we're going to go over in more detail. These concepts apply to any type of data, but we're going to hone in on how these concepts relate to beneficial ownership data specifically. These concepts are all interrelated to one another. Each one affects all the others either directly or indirectly. They include where the data physically resides, how the data can be searched for and retrieved, the quality of the data itself, how other systems can access the data for other purposes, and globally, how that data is secured from unauthorized access. So now we'll take a look at each of these concepts individually, but we'll start with data security. I bring up data security first because ultimately it really is the most critical concept from an overall risk perspective. Now, first and foremost, beneficial ownership data includes what's known as personally identifiable information, or PII, meaning date of birth and tax ID number. When you pair this with personal residence address, you have the perfect package of private information that, if it's leaked, can create havoc for the institution as well as for the people whose information was breached. Just think about some of the more recent big data breaches that have made the news in recent years. The International Organization for Standardization, otherwise known as ISO, has established 4 different levels of data security. Just to go over these briefly, the first level is level 1, which is confidential. This is the highest level of security, and it's usually reserved for things like payroll information and employee data and information, say, that might affect a stock price. Level 2 is called restricted. Now, this level is for information about the business or its customers that should never be shared publicly, but employees may need it to do their jobs. Level 3 is known as internal, and typically all employees have access to this level of data. Think of things like the internal phone directory, the employee benefit plan summary, and so forth. And level 4 is public, meaning there'd be no heartburn if it was released outside the organization. Some examples include press releases, daily published interest rates, or, say, the company's audited financial statements. In my opinion, beneficial ownership information falls under level 2, or restricted data. But it's important that you review your institution's own data security framework to see how this fits in with how PII is defined and classified. You'll want to decide whether to grant open access to beneficial owners PII in your organization. Does everyone need to be able to see it? If not, and you're storing your data electronically, see if your system will allow beneficial owners' tax ID, date of birth, and residence address to be redacted based on job function. In other words, certain staff, like, say, the compliance department or certain roles within it, would need access to this data, but it makes sense that most employees in the organization would only need to see the beneficial owners' names and their roles, and not their PII data, if at all. So your ability to search on, retrieve data is highly dependent on how it's stored and how accessible it is. What's important to know about beneficial owner information is that, first of all, you'll need to be able to find it from a variety of search perspectives. The primary purpose of this information is, first and foremost, for law enforcement. So they may come to you with an individual's name and tax ID and ask you for all the legal entity customers at your institution where they are a beneficial owner. Or they may give you the legal entity name and have you provide the beneficial owner's names and personal data, or it might be a combination of these two. Regardless, it's critical that you be able to supply law enforcement with an original or electronic facsimile of the beneficial ownership certification form that the customer supplied to you, along with any updates, related correspondence, and so forth. You'll also want this data to be searchable for your own analysis purposes in any combination of data elements. And we'll touch on internal analysis of the data later in the presentation. So when it comes to data of any kind, there are always retention requirements. Those imposed by FinCEN may often vary from generic legal standards, but they're actually meant to match up with international standards, which is 5 years. But 5 years from when? When it comes to beneficial ownership information in the CDD rule, FinCEN's supplementary guidance is a little confusing in my opinion. Now they say that the beneficial owner's identifying information, including the form, needs to be kept for 5 years after the account is closed. But verification records need to be kept for 5 years after the record is made. Now, I haven't been able to get a good definition of what they mean by verification records, but what I suspect is that this may mean the records you keep documenting how you verified the beneficial owner's identity. So let's say you have a new legal entity customer who opens an account in July of 2019. You collect their beneficial ownership certification form and their beneficial owner's identification. Then a little over a year later, this same customer opens a new account. Now, instead of getting a whole new form, you rely on the existing form you have on file and just get a confirmation in writing from the customer's representative that nothing has changed. And nobody's ID has expired, of course. But then 5 years go by, and this same customer opens another new account. This time, there have been changes to the beneficial owners, so you get a whole new certification form for this entity. So what do you have to keep, and how long do you need to keep it? Well, you could do all the math, but frankly, in my opinion, you should keep everything you collect about a legal entity customer for at least 5 years after the relationship ends, meaning the point at which they no longer have any accounts or services through your institution. Now, let's move on to the subject of data quality. We measure data quality for any type of data based on 5 basic characteristics. Is it accurate? Is it complete? Meaning there isn't anything missing or unusable about it. Does it conform to the standard format established for this type of information? Is it consistent? Meaning it doesn't conflict with other data values. And lastly, there should be no unnecessary duplicate records. Quality of beneficial ownership data is especially important because there are regulatory requirements surrounding it. There are a couple of important aspects to consider to ensure your beneficial ownership data is of high quality. First, you'll want to ensure that how beneficial ownership data gets into your database has good controls around it. If a human is manually entering data from a beneficial ownership form, make sure that there are data validations in place to ensure accuracy and completeness. The same goes for the other end of the spectrum, where, say, data is entered into an online form by the customer and fed automatically to the database. Be sure you have cross-checks and validations to ensure that they're entering everything as accurately as possible, such as not allowing blank fields or special characters in a field. Now, I know I've struggled over the years with various types of direct customer data entry where a field would be required, but the customer didn't feel like completing it, so they just input an asterisk or type an A. Regardless, you'll want to make sure that you regularly scrub your database to ensure that you don't have bad data or duplicate records. Now, this can often be a tedious process, but it's well worth it in the long run. There are also some unique data issues with respect to beneficial ownership that you'll need to be sure that you address within your database. For example, what if you have one individual who's named under both the ownership prong and the control prong? How will you address that? Or say there's one particular person who is a beneficial owner under several legal entity customers. And then there's the issue of tracking multiple versions of beneficial ownership data for a legal entity customer over time. So say, for example, from 2019 to 2021, you have a commercial client whose owners are Joe Smith Jr. and Joe Smith Sr. And in 2021, Joe Smith Sr. retires and Bobby Ray Smith, his nephew, assumes his ownership share. You'll need to keep records on all 3 of these guys, but also track that Joe Smith Sr. was once but no longer is a beneficial owner and when that happened. So as I said at the beginning, beneficial ownership data truly is a new frontier. We don't have any history yet or best practices to rely on to know how much of this data is really going to be requested by law enforcement. So the best approach is really the most conservative one, meaning keep everything and keep track of it carefully. Maintaining beneficial ownership data over time is yet another area of confusion and contention within the CDD rule. So much so, in fact, that FinCEN's first FAQ document published after the CDD final rule went into effect includes, by my count, at least 5 separate questions relating to this one topic. For instance, are you required to obtain an updated certification form every year, even if the legal entity customer hasn't opened a new account? Or what about changes to individuals named under the control prong, like the CEO, the CFO, etc.? certainly these people change roles much more frequently than ownership would. And what if there's an address change only for a particular beneficial owner? Well, FinCEN's responses routinely refer to risk-based procedures, which is somewhat frustrating because they don't define what risk really means here. You'll need to read the FAQ document in detail as there's just too much to cover in this presentation, but here are a few suggestions that you can start with. First, make sure your customer-facing staff know to be looking for evidence of changes in customer ownership as they go about their normal interactions with the customers, and that they have a central point of contact within the institution that they know to report these potential changes to. So that team can take over the process of following up with the customer for clarification. So let's use the example I just gave about the company owned by Joe Smith Jr. and Joe Smith Sr., where Sr. retires and transfers his ownership to Bobby Ray. And let's say Jr. and Bobby Ray come into the branch to get Bobby Ray added as a new signatory on the business account. And they explain the whole situation of what's going on with Sr.'s retirement and so forth. So the accounts representative who helps them should be trained to recognize this is a change in ownership, and they should refer this information to a designated team who would get a new beneficial ownership form out to them to complete. Now I say team here, but it could be whomever is assigned this role in your institution. Or even better, the accounts representative could even be empowered to collect a new certification form right there on the spot. Next, you'll want to identify any specific triggering events that would prompt you to review existing beneficial ownership information. Now, this could be as granular as flagging any identity document expiration date that's now passed, and then requesting an updated form at that time. At a higher level, anytime a legal entity customers goes through a merger, acquisition, or reorganization is really the perfect time to request an updated form. You, of course, need to obtain a new form when you know that one or more beneficial owners has changed under either prong. But that being said, FinCEN does tell us that if only an address or a new expiration date on a beneficial owner's ID has changed, we don't have to get a new form, just an image of the new ID or the new address information. But in my opinion, it's much safer to get a new form altogether because it's more consistent, it's easier to track, and it makes for a better audit trail. And there may have actually been changes that you weren't aware of that the customer has experienced. The last topic here on the subject of beneficial ownership data is about how this data can be of great benefit when it's shared across other systems within the institution. So some of these are your anti-money laundering monitoring system, and we'll go into that in more detail in the next section. Also your OFAC and other sanction screening system or systems. Because we must apply the standard CIP rules to beneficial owners, this means, guess what? We must also OFAC screen them at the time the new account is opened. And while I don't want to go into the intricacies of OFAC compliance today, just keep in mind that ongoing screening of these names is important to ensure that you're not doing business indirectly with someone who ultimately owns or controls an entity that's named on the OFAC list, or is himself or herself a sanctioned party who's hiding behind a legal entity. If your institution screens customer names for politically exposed persons, or PEPs, doing so for these beneficial owners would be advisable as well. It'd be good to know, for instance, that your legal entity customer happens to be indirectly controlled by, say, Nicolas Maduro's brother. And finally, having some of this data feed to your CRM database would also benefit the institution, but of course, keep the PII data out. Now let's move on to how you can use beneficial ownership information in your AML transaction monitoring and in your customer risk assessments. Now, here we have Senator Carl Levin, who's one of my inspirational heroes when it comes to fighting for financial transparency in the United States. And although he's retired now, throughout his career, he was a dogged proponent of having federal regulations, which is today completely controlled at the state level, in order to help stop anonymously owned shell companies from being used for money laundering, terrorist financing, and all kinds of illegal activity. This quote from him is one of my favorites, and one that I would frequently bring up when I got pushback on customer due diligence requirements from the sales side of the bank. I can tell you that in Colorado, where I'm based, you can form an LLC in about 10 minutes or less with an internet connection and a credit card. You don't have to name the owners of the LLC, just an agent for service of process. And I know this is the case in many other states. Now, although as compliance professionals, we may groan about all the mechanics of collecting and maintaining beneficial ownership data, we really should recognize that this is critical information that we've never had available to us before. Now, anonymous corporate formation is still very much alive and well in the US today. Sometime when you have a moment, just Google anonymous corporate formation and see what comes up. Corporate formation agents are still legal in this country and will give your LLC a physical address. They'll answer the phone in your company's name, and they may even, if you want to, provide nominee or proxy shareholders and directors. The CDD rule now helps us to mitigate but not entirely prevent anonymous formations by getting financial institutions to collect the information that the states refuse to. Now, keep in mind, of course, that the data we're getting is being supplied by the customer and in most cases is not verifiable through any independent source, but it is a big step in the right direction. So now we have information available to us that'll help us identify high-risk transactions and ownership structures. More on that in a moment. So now we have the beneficial owners of our legal entity customers available to us, there are some great ways that we can use this information in our monitoring and our risk assessments. First of all, we can now identify accounts within the institution that are held by seemingly unrelated companies, but which in reality are controlled by the same people. Knowing these relationships helps us assess the risks associated with these interconnected accounts and customers that we never knew before were actually related to each other. We might also uncover structures of shell companies, which don't seem to make any logical sense or have any real legitimate business purpose. This in turn allows us to flag such customers as high risk and might even prompt a SAR filing if it looks like something illegal, such as maybe tax evasion, is the underlying reason for this complex structure. And knowing these once hidden relationships lets us monitor for transactions between these individuals and entities, whereas before they would have probably gone unnoticed. I want to touch briefly on the concept of householding, as it could be used with beneficial owner data. Now, householding is a technique that's been used for a long time in the financial services industry to group accounts according to some common client demographic, rather than just identifying accounts and grouping them by tax ID or by account number. In a typical consumer householding scenario, accounts owned by different family members under their own names and tax IDs would be combined under a household record so that the financial institution can recognize these as interrelated, even though on the surface they would not otherwise be. And we can use this concept of householding for beneficial owners. This diagram shows that John Smith is the beneficial owner of 4 separate and very diverse legal entities. So if all of these entities have accounts at one financial institution, that institution could create a household under John Smith to tie all these legal entity customers to him as beneficial owner. Taking this example a step further, now that we know these interrelationships, we can improve overall customer due diligence by examining the big picture, not just each legal entity customer in isolation. So what are some of the higher risk characteristics of this structure that may give us pause and perhaps need to dig deeper? Well, here are some of them. First, we have 4 very different legal entities, but one beneficial owner tied to them all. Not necessarily all that unusual, except that they are all domiciled in separate states. And 3 of the 4 are states that actively promote anonymous corporate formation, that being Wyoming, Delaware, and Nevada. Some further investigation that I would perform when conducting due diligence on John Smith and these legal entities would be to first look at their physical addresses. Are they all the same? Or if they're different, when you Google the address or addresses, do you find that there are dozens of companies with the identical address? If so, this means that these entities are hiding behind a corporate formation agent. I'd also want to see just how many layers do you need to peel back to get to John Smith as the ultimate beneficial owner. If there are lots of intermediary holding companies, there's something that doesn't smell quite right and needs an explanation. There's also a distinct possibility that John Smith may be a nominee shareholder. Now, if you've never heard this term, nominee shareholders, and there's also nominee directors, are just ordinary people who get paid by corporate formation agents to allow their names to be used instead of the real shareholders or directors so that those can remain anonymous. This is entirely legal, and it's done under a complex and sort of tenuous power of attorney type of relationship that's arranged by the corporate formation agent. Now, one of the great things about the CDD rule is that we now get to see John Smith's identity document and residence address. Then we can run a background check on him to see if he's who he appears to be. And finally, we can look at this from the big picture perspective and ask, does all this have a reasonable business purpose? So now that you have all this information about these legal entities, how they're interrelated, and how John Smith fits into the picture, you can use your AML transaction monitoring system to flag unusual patterns of activity between these unrelated businesses. You might choose to flag every transaction or just ones over a certain dollar limit, or aggregated over a time period like a day, 3 days, etc. You want to be especially alert for wire transfers in and out of these accounts and any foreign wire transfers, either outgoing or incoming. You could also flag any transaction between John Smith, who's not an account holder, and any of these businesses who are account holders. As well, you could have your system look for patterns of transactions with other entities or individuals over a certain dollar amount, look for aggregated patterns of deposits and withdrawals, and so forth that don't seem to have a valid business purpose. Now, transaction monitoring systems vary significantly by how sophisticated their tuning process is. So be sure to get help from your vendor if you're not familiar with it. Now, our final topic today is about how good documentation can be the key to successful regulatory compliance. So first, a little background. Most of our U.S. anti-money laundering regulations are written in a very broad context. This is because we have so many different types of financial institutions, and every one of them has its own unique customer base. So the regulations frequently require each institution to develop its own risk-based compliance processes using the basic regulations as a framework. And the CDD rule is no exception, and it is especially broad, combining that with the fact that because the original final rule had so many ambiguities and missing clarifications, multiple supplementary guidance documents and FAQs have been published by FinCEN over the past year, and probably more to come, which in essence become de facto regulation. So how do you as a financial institution ensure that you're complying with everything and in the appropriate manner? Well, the answer lies in having complete and clear documentation. So what's meant by good documentation? Well, in my opinion, good regulatory compliance documentation provides clear answers to these 4 questions. What processes, procedures, or steps are occurring? When do these take place? Who is responsible for performing them? And perhaps most important, why did the institution choose to implement these particular processes? So why document the why? Well, there are several very good reasons for this. First and foremost, it clarifies to your regulator, your internal audit group, senior management, and for posterity, exactly what was your rationale in implementing a particular process. How many times have you questioned why a particular procedure exists that seems to make no sense to you, and no one has an answer why other than, well, that's just the way we've always done it? This drives me nuts. So documenting the why behind a process for posterity helps eliminate that. So auditors and regulators love that you are able to document the specific regulations and supplementary guidance that you relied on in determining a particular process. And it also gives you the opportunity to describe the unique factors involved in coming to a decision around a process when there's some ambiguity in the associated regulation. Again, think CDD rule. And last, as I just described, it takes the anecdotal aspect away for future generations of staff and management. So to illustrate the concepts I've just described, let's go through a very simplistic example where, say, a financial institution is documenting their process around the beneficial ownership certification form. So first, the what. The bank will use its own beneficial ownership certification form, as opposed to the sample form provided in the rule, that'll allow each customer to select its legal entity type and, if applicable, self-exempt from beneficial ownership reporting. Now, as a side note, this is something we discussed in detail in part 1 of this webinar series. So if you need a refresher or haven't listened to that yet, you'll want to go back and listen to that. Next, the when. The certification form will be provided in hard copy to every business customer that opens a new account during the application process. Now, who will do this? The relationship manager or the new accounts officer, as assigned by client or branch, is responsible for delivering the certification form to the customer, obtaining the completed and signed form, and delivering it to compliance. And last but not least, the why. So here the bank is stating what was their rationale behind these processes. So the CDD rule states that financial institutions do not have to use the sample form provided by FinCEN in the final rule, and that they may develop their own form. The relationship manager or new accounts officer is the customer-facing representative of the bank and the client with the client, and therefore is in the best position to provide the form to the client, obtain the signed version, and deliver it to compliance. So as you probably know, documentation resides in a variety of formats. Depending on how it's used, who's using it, and the level of granularity the user requires. This graphic displays one suggested way of maintaining documentation across multiple formats. And it all starts with something I called a decision document. Now, this was something I found great success with in building the AML compliance function at my bank. So just what is a decision document? Well, first and foremost, it's an in-depth record of the what, who, when, and especially the why. It houses the institution's regulatory interpretation on which they've based a particular process or processes and describes those processes at a high level. So think of the simple example we just walked through. All of this content would be contained in a decision document. Auditors and regulators love decision documents, I have found, because it gives them everything they need in one place, rather than having to go around asking half a dozen people in order to get a complete picture. And then when desk procedures, forms, and checklists are designed, they all cross-reference back to the decision document. So no more guessing why something is being done a certain way. And one other very helpful side effect of using decision documents is that when they're being created and the underlying processes defined or updated, everyone with a stake in the game gets to participate and ultimately agree on the end design. Then you record the names of each stakeholder and the date that they signed off on it. So this results in no more, well, I never agreed to that, because it's been documented. So now let's recap the highlights and key takeaways from our presentation today. First of all, recognize that beneficial ownership data is something very new and unique for financial institutions to collect, store, and manage. Next, data security is extremely important, as beneficial ownership includes personally identifiable information. When it comes to data retention, I recommend that you keep all versions of beneficial ownership data supplied by customers including both the forms and any updates that they give you in writing, for 5 years after the account is closed at a minimum, but even better, keep it all for 5 years after the entire customer relationship ends. The data quality is critical. We all know the saying, garbage in, garbage out. Next, you'll want to identify what will be your triggers for updating beneficial ownership data or getting a new form altogether. Recognize that beneficial ownership data helps you see the hidden links. That can be a significant value in your AML, PEP, and sanction screening processes. And finally, really put forth the effort to clearly document your regulatory processes, including the what, when, who, and especially the why. The time that you put into doing this upfront will pay big dividends for years to come, I promise.
Well, thank you very much, Laurie. Before we do sign off, on behalf of Caseware, I would like to thank Laurie Kelly for today's presentation, and of course our participants for attending today's event. So for all our attendees, I assure you we will be emailing you links to the recordings, the slides, and the Q&As, and also a white paper where we have summarized a lot of the information provided by Laurie. We hope that you found this presentation useful, and if you have any other questions, please contact us via email or visit our website at alessa.caseware.com. Thank you very much again, and have a great day.